Hello everyone, welcome to Legal Darshan. In today's video, we are going to discuss case number 52, which is the Swiss Ribbons Private Limited and another versus Union of India and others case. Now, this case decided by two judges bench, Justice Nariman and Justice Naveen Sinha in the Supreme Court of India. It is dealing with the constitutional validity of the Insolvency and Bankruptcy Code of 2016. Now, basically, what happens in this case is that the question that is there before the court is that in 2016, India introduced the Insolvency and Bankruptcy Code. The Indian Parliament introduced the Insolvency and Bankruptcy Code to address the growing issues of non-performing assets and to, streamline the process of insolvency resolution. However, the Insolvency and Bankruptcy Code, is facing certain constitutional challenges which led to this particular case, which is Swiss Ribbons versus Union of India. Now, petitioners have argued that in certain provisions of IBC, which is Insolvency and Bankruptcy Code, some provisions were discriminatory, and those violated the fundamental rights enshrined under Article 14 of the Constitution of India. Now, the key concerns basically included that IBC, the Insolvency and Bankruptcy Code, it carries the provision which promotes differential treatment of the creditors. IBC distinguishes between financial creditors like, bank, and operational creditors like service providers or suppliers. And petitioner claims that this distinction is arbitrary. Now, another challenge was brought to Section 29A of the Insolvency and Bankruptcy Code, and that particular challenge pertained to promoters. Okay, now the main question was Section 29A barred those promoters of the company who mismanaged or defaulted from bidding for their own company during insolvency. So Section 29A is laying down some parameters to stop the promoters from, bidding for their own companies during insolvency. And this provision was specifically with respect to defaulting promoters. Okay, now the petitioners are challenging that this is an overly restrictive measure that is contained in the IBC. And another challenge included the composition of committee of creditors, which basically primarily has been composed of financial creditors and who had significant control over the insolvency process. And the challenge pertained to concern about fairness, concerns about transparency, etc. Now, the Supreme Court but Union of India in this case basically establishes, Union of India, who is the respondent, establishes the fact that the purpose by which such provisions were brought in IBC, that purpose has been resolved with respect to NPAs, with respect to crystallizing the process of insolvency resolution, and growing issue of non-performing assets has been, in control with implementation of IBC code. So Union of India basically establishes that this code, by whichever purpose it has been formulated, that purpose is in line of being achieved. So now Supreme Court herein, what Supreme Court did, it upholds the constitutional validity of Insolvency and Bankruptcy Code. Okay, so the court gives the reasons. Yes, the court herein gives the reason that yes, that financial creditors, the distinction that is being led in the financial creditors and the operational creditors, it carries an intelligible differentia. The classification is rational, and hence it does not violate the Article 14 of the Constitution of India. Court herein recognizes that financial and operational creditors have different kind of roles, have different kind of risks, and that is why the code, when it is providing a differential treatment, it is justified because of their varying roles and varying risks. Now, court herein is also saying that to prevent misuse of the insolvency process, barring defaulting promoters was deemed necessary. Okay, so it is important that Article 29A, which bars the defaulting promoter, the provision is upheld so that a misuse of the insolvency proceeding that happens in line with the IBC, it can be prevented. And with respect to the question that raised around COC, which is the committee of creditors, court emphasized that even we understand that COC does have substantial power, committee of creditors do have substantial powers, but their decision is subject to judicial review also. So that's how the checks and balances can be maintained, right? Now court herein is also identifying that financial creditors are best equipped to assess the viability and feasibility of the business of the corporate debtor and evaluate the contents of a resolution plan. But on the other hand, operational creditors are the ones who are basically service providers, who are suppliers. They are only involved in recovering amount that are paid for such goods and services, and therefore they are not always able to assess viability and feasibility of the business. So when these two have different roles, then in that case, why there is no issue if there is a differential treatment that this act is providing, and the same can be upheld in the light of intelligible differentia, which is one of the integral principles to determine if there is a violation of Article 14 or not. So this is it, which was held in the case of Swiss ribbons. I hope the discussion is useful. Thank you for watching. Please stay tuned with us on Legal Darshan. Keep liking, sharing, and subscribing to the channel. Thank you, everyone. Have a nice day.